313.1, explain the different types of offenses. Offenses are classified based on their severity and the nature of the violation. Number one is felonies, serious criminal acts punishable by death or state prison confinement for a term exceeding 1 year. 2, misdemeanors, less severe criminal acts punishable by a maximum sentence of 1 year in a county jail. 3, non-criminal violations, minor offenses such as traffic infractions that do not carry jail time, do not result in a criminal record, and are penalized solely through monetary fines or civil sanctions. 4, local ordinances, violations of county or municipal codes, usually restricted to civil penalties or small fines. 313.2, differentiate between felony and misdemeanor offenses. The core distinction lies in the severity of the potential penalty and the place of incarceration. Felonies involve major harms, example, grand theft, homicide, and carry state prison sentences exceeding 12 months or capital punishment. Misdemeanors involve less severe harms. Examples are petty theft, simple battery, and carry a maximum penalty of 12 months in the local county jail. 313.3, relate offenses to their associated penalties. Under Florida law, offenses correspond to a standard hierarchy of maximum statutory penalties. Capital felony, death or life imprisonment without parole. Life felony, life imprisonment and a fine up to $15,000. First degree felony, up to 30 years in prison and a fine up to $10,000. Second degree felony, up to 15 years in prison and a fine up to $10,000. Third degree felony, up to 5 years in prison and a fine up to $5,000. First degree misdemeanor, up to 1 year in county jail and a fine up to $1,000. Second degree misdemeanor, up to 60 days in county jail and a fine up to $500. Non-criminal violation, no incarceration, monetary fines up to $500 or civil penalties. 314.1, explain how to find and read the Florida statutes. The Florida statutes are organized logically by title, chapter, section, and subsection. For example, in Statute 790.065, Section 13, FS 790, the 790 represents the chapter, weapons and firearms. 065 represents the specific section within that chapter, and 13 denotes the unique subsection. These statutes are accessible online via the official portal, where they are indeed indexed numerically and include annotations, historical notes, and cross-references. 314.2, identify the conditions and criteria that result in enhanced penalties. Statutory penalties can be reclassified or elevated to a harsher sentencing bracket under specific conditions, including the use or possession of a firearm or weapon during the commission of a crime. Example, 10 to 20 to life. Committing a crime against a protected victim class, such as a law enforcement officer, correctional officer, firefighter, or elderly person. Committing an offense motivated by prejudice, bias, or hate against a victim's race, religion, ethnicity, or sexual orientation. The defendant's status as a habitual felony offender or career criminal. 314.3. Describe the two categories of parties to a crime. 1. Principal in the first degree. An individual who helps commit a crime or whose actions caused the crime to occur, regardless of whether they were physically present when it was committed. or when it was completed. Under Florida law, a principal is treated with the same level of legal culpability and faces the same maximum penalties as the person who physically executed the act. Number 2, accessory after the fact. An individual who knowingly provides aid, shelter, assistance, or means of escape to a felon after the crime has occurred with the specific intent to help that felon avoid detection, arrest, trial, or sentence. 321.1. Describe the concept of criminal intent. Criminal intent represents the conscious state of mind and purpose an individual maintains while committing a prohibited act. To establish criminal liability, the state must generally prove both the physical illegal act, or the actus reus, and the corresponding blameworthy mental state, the mens rea. 321.2. Explain the legally recognized categories of criminal intent. You have general intent, which is the conscious intent to do the physical act that the law forbids without requiring a specific desire to bring about a particular harm or consequence. You have specific intent, which is a deliberate mental plan to accomplish a precise, prohibited result or malicious outcome that goes beyond the basic illegal act itself. And you have transferred intent. This is a legal doctrine where a person intends to harm one specific victim but accidentally hurts another. The law transfers the intentional state of mind to the actual victim harmed. Recklessness and criminal negligence. This is a gross deviation from the standard of care where an individual flagrantly disregards a massive, unjustifiable risk to human life, creating criminal liability, even without an explicit intent to harm.